Welcome to the 5-Minute Legal Master Series, where expert attorneys help you master important legal topics. Today, board-certified creditors' rights and business bankruptcy attorney Kirk B. Burkley discusses when to involve an attorney in a bankruptcy case.
Today's topic is when to involve an attorney in a bankruptcy case. This is a question that we often hear from clients and other people in the business, which is, hey, the company went bankrupt, which doesn't that mean they don't have any money? So why would I hire an attorney to help me in this case? And isn't that just throwing good money after bad? The answer is, it depends. So let me just start out with the basic notion that bankruptcy is definitely one of those places where the squeaky wheel gets the grease. Oftentimes in a bankruptcy proceeding, the debtor has, for some period of time prior to the case, been fending off creditors, either creditors such as their bank trying to foreclose on property or other assets, unsecured creditors that have filed lawsuits, some sort of proceeding that has caused the debtor to say, I need to avail myself of the automatic stay and stop all these creditor collection activities. So those creditors that drove the company into bankruptcy have already taken some action that is now stayed by the bankruptcy case. And usually then what happens is some other creditors, maybe it's the same creditors, maybe it's others, show up in the bankruptcy case demanding payment. And the debtor is probably trying to survive on its last legs or attempting to get a sale done, and they're going to take care of the creditors that are preventing them from doing that. So creditors that sit back and do nothing in the case, even if they're not being paid later in the case, or even if they have some interest that could be protected, oftentimes the debtor is going to ignore them. So does that mean that because you see a bankruptcy case you automatically get an attorney involved? No, of course it doesn't mean that, because you first have to evaluate what is the interest that you're protecting, and is it worth hiring an attorney to protect that interest. One of the basic notions in bankruptcy is that creditors should not be hurt worse after the date of filing of the bankruptcy than they were prior to the filing of the bankruptcy. So post-bankruptcy, the debtor is supposed to be paying everybody it does business with. So again, you're not supposed to get further into the hole post-bankruptcy than you were on the date of filing. If the debtor is not able to pay its cost of administration, what we call administrative expenses in the bankruptcy case, then the case should either be dismissed or converted, and the court should not let the debtor continue to remain in bankruptcy. So if you have a secured claim and there is collateral to secure your claim, so maybe you're a bank or you loaned money on a secured basis to the debtor, then more often than not you should be protecting your interest and making sure the debtor is paying you, or you should move to recover your collateral so that you can sell that collateral and pay off your claim. If you are a vendor that's doing business with the bankrupt company after the filing of the petition, you should also be getting paid. And if you're not, then you should protect that interest, because an administrative claim is a top priority claim that has to be paid 100 cents on the dollar in order for the debtor to confirm a plan. So in that case, so long as it's worth it by terms of dollars and cents, you should be protecting that interest. Similarly, if you have an unexpired lease or an executory contract, you should be making sure that the debtor is performing under that contract, and hopefully they will eventually assume that contract so that you can get paid going forward into the future. But again, it all takes a discussion with your attorney, an analysis of the cost and benefit of participating and protecting your interest in the bankruptcy case, and whether or not the claim is of a significant value that it's worth it to you, and taking the extra step in bankruptcy just might make the difference between getting paid or not getting paid.
You've just heard the 5-Minute Legal Master, where expert attorneys help you master important legal topics. For more information on this and other topics, please visit 5minutelegalmaster.com.